My grandmother smelled like lavender and motor oil. People always found that combination strange, but I thought it made perfect sense. She restored vintage cars in her garage every weekend until she was 73 years old, and she kept a bar of lavender soap by the utility sink because she said a lady should always smell like a lady, even with grease under her fingernails. She was the most deliberately herself person I have ever known. She left me everything. I didn't find out until 3 weeks after the funeral, sitting in a conference room in downtown Raleigh across from her estate attorney, watching my older sister's face go completely still. Not sad still, calculating still. The kind of stillness that means someone's mind is already moving very fast in a direction you don't want them to go. My grandmother's name was Iris. She had a 4-bedroom house in a quiet neighborhood in Cary, North Carolina, a savings account with more in it than I'd realized, a 1967 Ford Mustang in cherry condition, and 42 years' worth of her late husband's life insurance that she'd invested carefully and touched almost never. She also had 2 granddaughters, me and my sister, and 1 son, my father, who had been in and out of her life for most of my childhood because he found stable things boring and unstable things exciting, and that combination had consequences. My sister and I are 7 years apart. She raised me, in a way, after our mom left. She drove me to school and signed my permission slips and taught me how to do laundry when I was 9. I loved her for all of that. I still do, in the way you love someone whose shape has changed into something you don't recognize anymore. Her name is Vivienne. She's 41. She is very good at seeming reasonable. After the attorney finished reading the terms of the will, Vivienne didn't cry or yell. She just nodded slowly, like she was absorbing information, and said, "I'd like to see the original document." The attorney slid it across the table. She looked at it for a long time. Then she looked at me. "We need to talk," she said, "privately." We stepped into the hallway. She folded her arms and told me calmly that Gran had clearly been confused in her final months, that the Alzheimer's diagnosis changed things, that she wasn't sure the will reflected Gran's actual wishes, that she thought we should work this out as a family before it became something adversarial. I stood there listening and felt something go cold in my chest, not because of what she was saying, because she was saying it before we'd even made it to the parking lot. There was no Alzheimer's diagnosis. Gran had been sharp until the last week of her life. I had visited her twice a month for 3 years. I knew her doctor, knew her medication list, knew the crossword puzzle she did every morning in pen. The attorney had already confirmed she was of sound mind when she signed. All of that was in the documents. Vivienne knew this. She was there for the same visits. I told her I needed some time to process everything. She said, of course, take all the time you need," and she hugged me in the parking lot and drove away in her Lexus. I sat in my car for 10 minutes before I could make myself start the engine. That was in February. By April, I had received a formal letter from an attorney I didn't recognize, informing me that my sister was contesting the will on the grounds of undue influence and diminished capacity. I want to be careful about how I describe what happened next, because if I'm not careful, it's going to sound like self-pity, and this story is not about that. I was 29 years old, working as a physical therapist's assistant, living in a 1-bedroom apartment in Durham. I did not have money for a legal fight. I did not have connections or strategy or any real understanding of what contesting an estate even meant in practical terms. What I had was a box of papers from my grandmother's house that I'd been meaning to sort through. A group of friends who were very supportive in the way that people are when they don't know what else to offer. And a very specific memory of something my grandmother told me the last time I saw her. She was lying in the hospital bed they'd moved to her living room because she had refused to go to a hospice facility and nobody was willing to fight her on it. I was holding her hand. She was tired but clear-eyed, and she said to me, "I need you to promise me something." I said, "Okay." She said, "Don't let them make you feel like you owe them something just because they're family. You don't owe anyone a debt they invented." I didn't fully understand what she meant until I was sitting across from my sister's attorney in a conference room 6 weeks later, being asked a series of careful questions about how often I'd visited Gran, whether I'd ever assisted her with finances, whether I'd ever been present when she spoke to her own attorney. The implication was obvious. They were building a narrative that I had positioned myself to influence an elderly woman, cultivated her trust and her isolation, and steered her toward changing her will in my favor. They used the phrase systematic manipulation in one of the filings. I read it on a Tuesday morning and had to sit down on my kitchen floor. Here is what was true. I visited Gran because I loved her. I drove 2 hours round trip because I wanted to. I helped her with groceries because she asked me to, not because I was engineering proximity. I was present for one conversation with her attorney, which happened by accident because I stopped by on a day he was already there, and I left the room when the legal discussion started because it wasn't my business. Here is what my sister had: a neighbor who would testify that I visited unusually frequently, a statement from my father, who had missed my grandmother's 80th birthday and her husband's funeral and most of the years in between, saying he believed Gran had been not herself in her final year, and an attorney who was very good at making reasonable-sounding things out of flimsy material. I found my own attorney through a referral from a woman at my office whose family had gone through a similar situation. Her name was Ms. Holloway, and she was 60 years old and wore reading glasses on a beaded chain and spoke to me like someone who had seen a great many things and found very few of them surprising. I told her everything. She listened without interrupting. When I finished, she said, "Do you have documentation of your visits?" I did, actually. I had kept a journal since college, nothing formal, just a notebook where I wrote down things that happened. And a lot of those entries were about my visits to Gran. Dates, what we talked about, what she was eating, how she seemed. I had photos on my phone with timestamps. I had text messages between us going back 4 years. I had voicemails I'd never deleted because I couldn't make myself. "Good," Ms. Holloway said. "What about the neighbor?" The neighbor's name was Mr. Aldridge. He'd lived next door to my grandmother for 17 years and considered himself something of an authority on her life. He and Vivienne had apparently been in contact. I didn't know the details of that relationship, but I knew that my grandmother had mentioned more than once that she found him intrusive and that she'd stopped leaving her garage door open while she worked because of it. Ms. Holloway filed a response to the contest. She documented my grandmother's medical history, her cognitive assessments from the past 3 years, the dates and nature of her interactions with her estate attorney. She requested the full file from Gran's doctor. She issued a discovery request for all communications between Vivienne and the contesting attorney going back 18 months. Vivienne's attorney objected to that last part. Ms. Holloway let it sit. In June, something happened that I still don't entirely know how to explain. I had been going through the box of papers I'd taken from Gran's house, the one I'd been meaning to sort through since February. It was mostly mundane things: appliance manuals, old Christmas cards, a folder of recipes clipped from magazines. Near the bottom there was a manila envelope with my name written on it in Gran's handwriting. Inside was a letter. It was dated 11 months before she died. She'd written it by hand, 4 pages, in the careful cursive she'd learned in elementary school and never abandoned. She wrote about her reasons for the will. She wrote about her history with Vivienne, not cruelly but honestly. She wrote about a conversation she'd had with Vivienne 2 years earlier. during which Vivienne had asked her directly to change the will so that the estate would be divided equally, and had implied that the current arrangement was the product of my having manipulated her. Gran wrote that she had not changed the will. She wrote that she understood there might be a dispute after she was gone, and she wanted me to have this letter, and she wanted me to know that every decision she'd made was her own. She also wrote that she had kept a copy of the letter with her attorney, with instructions to provide it to Miss Holloway in the event of a legal challenge. I sat on my kitchen floor again. This time it was different. I called Miss Holloway. She already knew about the copy. She'd been waiting, she said, for the right moment to introduce it. She wanted the full Discovery picture first. What came out of Discovery was not a surprise to her, though it was to me. The communications between Vivienne and the contesting attorney went back not 18 months, but 26. They had begun planning this the year before Gran died. There were emails discussing the will, discussing strategy, discussing which family members might be persuadable to testify. There was one email in which Vivienne referred to my visits to Gran as the problem we need to reframe. There was also a series of communications with Mr. Aldrich. He hadn't been a spontaneous witness. He'd been a recruited one. I want to say I was shocked. I wasn't, exactly. I was something worse. I was the thing you feel when something you already half knew becomes completely visible. The estate dispute went to a hearing in September. It was not a jury trial. It was a judge, a courtroom, 2 tables of attorneys, and my sister and me sitting on opposite sides of the room without looking at each other. Vivienne's attorney gave a long opening. He talked about family bonds and elderly vulnerability and the responsibility of the court to protect those who could not protect themselves. He said my name 12 times in the first 10 minutes. He made me sound like someone I have never been. Miss Holloway's opening was shorter. She said, "We will demonstrate that the testator was of sound mind, that the will reflects her genuine and carefully considered wishes, and that the challenge to this estate was planned and coordinated long before the testator's death by parties with a financial interest in its outcome." She put Gran's doctor on the stand first. He walked through 4 years of cognitive assessments. Gran's scores were normal. Her judgment was intact. Her final assessment, 8 months before her death, showed no signs of diminished capacity. Vivienne's attorney cross-examined him for 45 minutes and got nowhere. Then Miss Holloway introduced the letter. I watched my sister's face when the judge read it. I had been watching her all morning, and she had been composed, controlled, a portrait of dignified concern. When the judge read the letter, something shifted. It was small, just a tightening around her eyes, a barely perceptible stillness. But I had known her face my whole life, and I saw it. Gran had written, in part, that she was aware her older granddaughter believed the estate arrangement to be unjust, and that she had listened to those concerns, and that she had not changed her position, because her position was based on things she knew and had decided. She wrote that she loved both of her granddaughters. She wrote that love was not the same as debt. The judge looked up from the letter and asked Vivienne's attorney one question. He said, "When were your clients first made aware that the will would not be altered in their favor?" There was a pause. The answer, the honest answer, was 26 months before the hearing. The answer embedded in those discovery documents was that they had known early, planned accordingly, and filed the contest not out of genuine concern for Gran's well-being, but out of a strategic decision made long before her death. Vivienne's attorney said they would need to confer with his clients. The judge said they could take 10 minutes. Those 10 minutes were the longest I have ever sat still in my life. I looked at my hands. I looked at the flag in the corner. I thought about my grandmother in her garage with her lavender soap and her socket wrenches, and the specific way she laughed when something surprised her, which was a sudden loud sound like she hadn't expected to find it funny. When the recess ended, Vivienne's attorney stood up and said that his clients were withdrawing the contest. Just like that, 26 months of planning, 6 months of litigation, and it ended in 10 minutes in a beige courtroom in Wake County with my sister staring at the table and my father not even present to watch what his statement had been used for. Ms. Holloway walked me out of the courthouse. It was a Tuesday in September, and the air was starting to think about being fall. She said, "Your grandmother was a very organized woman." I said I knew. She said she wrote that letter before anyone filed anything, before anyone even threatened to file anything. I said I knew that too. She knew, Ms. Holloway said. She prepared for you. I cried in the parking garage, not the restrained, dignified kind, the kind that comes from somewhere below language, the kind that you can't time or manage. I sat in my car and cried for a while, and then I drove home. My sister has not reached out to me since the hearing. My father called once about 3 weeks later. He said he hadn't fully understood how his statement would be used. I listened to him say that. I said I needed some time. He said he understood. I haven't called him back yet, and I'm not sure when I will. The house in Cary is mine now. I've been going there on weekends to sort through things slowly, not to empty it, but to understand it, to learn what was kept and what was saved and what it means. There's a room off the kitchen that Gran used as a kind of study, full of shelves of books organized by her own system that I haven't fully decoded yet. I've been sitting in there on Sunday mornings with coffee, trying to figure out the logic of it. The Mustang is in the garage. It runs. I've driven it twice, once around the neighborhood, once on the highway, pushing it to see what it wanted to do. The engine is original, and it sounds the way I imagine the word fearless would sound if it were a noise. I'm not going to sell it. Gran told me once that the difference between things that last and things that don't is usually just attention. She meant it about cars, but she applied it to everything. She paid attention to what she valued. She paid attention to what she wanted to leave behind. She left me a house, a car, a savings account, and a 4-page letter that stopped a 26-month legal strategy cold in a Wake County courtroom. She also left me the memory of lavender and motor oil and the absolute certainty that she knew exactly what she was doing every single step of the way. I carry that with me now like it's mine, because it is. I've thought a lot about what actually stopped Vivienne that day in the courtroom. It wasn't the judge. It wasn't Miss Holloway. It was a 4-page letter written in careful cursive by an old woman who smelled like lavender and motor oil, who had the quiet foresight to write down the truth before anyone could rewrite it. That's the part that stays with me. Gran didn't fight back loudly. She didn't confront Vivienne directly or make ultimatums or involve attorneys while she was still alive. She just paid attention. She saw what was coming, and she prepared, not out of bitterness, but out of clarity. She knew that the people who truly love you don't need to outmaneuver anyone. They just need to tell the truth clearly enough that it holds. I think about Vivienne's 26 months of planning, the emails, the recruited neighbor, my father's statement drafted and signed before Gran had even taken her last breath. So much effort, so much strategy, and all of it dissolved in 10 minutes because one woman had sat down at a desk almost a year before any of it started and written honestly about what she knew. There's something in that I keep returning to. Not satisfaction exactly. More like a slow understanding of how things actually work when you're patient enough to watch. The effort Vivienne put into constructing that case, the coordination, the legal fees, the careful framing. It was enormous, and it collapsed not because someone outmaneuvered her, but because it was built on something that wasn't true. That's always the structural problem with dishonesty. It requires constant maintenance. The truth just sits there and waits. I didn't do anything heroic in this story. I visited my grandmother because I wanted to. I kept a journal because I always have. I saved voicemails because I couldn't let go. None of that was strategy. It was just what a person does when they're paying attention to the things that matter to them. And somehow, all of it became exactly what I needed. I think that's what Gran meant when she said, "You don't owe anyone a debt they invented." She wasn't just talking about money or inheritance. She was talking about the guilt people manufacture to keep you manageable, the obligation to shrink yourself, to apologize for being loved, to hand over what belongs to you in order to keep the peace. She had spent enough of her life watching that dynamic operate in her own family, and she was done with it. She prepared a letter instead. The Mustang is in the garage. The house is still full of her things, her books, her logic. I'm learning the shape of what she left behind, slowly, on Sunday mornings with coffee. I'm not in a hurry. She wasn't either, and she got everything right. What I know now is that integrity isn't something you perform in a crisis. It's something you build quietly, in ordinary moments, so that when the crisis comes, it's already there, solid, documented, undeniable. Gran built hers over a lifetime. The courtroom was just the place where it finally became visible. I carry that like it's mine, because she made sure it would be.